And now I would like to announce the panel discussion. The panel discussion is going to be about the topic turning notes into rights, protecting creativity in the music industry.
As someone deeply involved in commercial law and IP strategy, I've seen the firsthand how musicians often struggle to translate their creativity into productive assets. Today, we have with us a powerhouse panel of legal minds who bring decades of expertise across IP enforcement, litigation, and advocacy. Together, we explore how law intersects with music, from copyrights, registration, courtroom battles, and from monetizing strategies to digital disruption arena. Ashok sir, I have first question to you. With your immense experience in IP litigation and enforcement, could you walk us through the biggest risk artists face when they don't secure their IP early?
The first risk is risk of losing the work itself, right? So when you go for IP protection, what are you doing? You are actually protecting your IP and seeking for a statutory right. That is most important. So once you get a statutory right, that can be enforced. The next point is that, others may copy your work, they may distribute it, they may make money out of it. That is, and the third very important issue is when the music director or the singer, they assign the work to someone. You should always know the assignment has to be done for an extended period. If the assignment deed does not talk of a period, then the right will come back to the person after 5 years. So these are the three main things. Apart from that, what other things happen is when you lose the right, you don't have a facility to collaborate, you don't have a facility to monetize, right? So fundamentally, protection is very important.
Suresh sir, coming from the courtroom's heavy background, how have you seen copyright claims evolving over the past decade, particularly in the music region?
Now, that's a question relating to enforcement rather, I would say. Because if you see any legal regime, but most of you, those with a little background of understanding copyright law, India is a signatory to TRIPS and Berne Convention. Now, for anybody to enjoy any right of copyright, you would have to need two things. One, the very law that defines your rights. Two, its enforcement. There's a very simple economic principle when you talk about intellectual property rights. When the property rights are well defined, when your transaction cost to enforce a certain right is zero, then the possibility of you protecting your right is there. Speaking from an Indian perspective, if you see the courtroom system, I am a Ekalavya Shishya of Ram Kumar sir. A decade ago, I was not an IP lawyer, but when one some of the cases which he left, they came to me because I had civil knowledge to enforce a IP right. So that's how I started getting into the IP business. Then IP business, I started understanding. The biggest challenge that I faced was interim orders are not quick. This you won't disagree with. And final adjudication takes almost half a decade. Now, what is contributing to this? Obviously, if I start talking about what is the definition of a copyright, what is sound recording, what is cinematic rights, if I talk about all of these things, none of the common public will ever understand. I'll go back to the first lecture that was there. They were talking about you're playing my music and you're not paying me royalty. Who knows what is your music? Ignorance of law is non-excuse act. And you have no idea what the copyright is all about. All shadis, festivals, you start playing. Even if you go to a cloth storeroom or a showroom, there will be music being played. But you do not know whether that is a copyright or not. I was just on the way coming back, I heard a song called Ranu Bombay Ki Ranu. Some song is there, folklore song. It's become private song. It's a very folklore song. Now these are getting new adaptations. The person who makes the new adaptation, can he claim a right? And if he claims a right, how do you enforce it? Now question comes again. When you come to enforcement, who's your lawyer to fight your case? Do we have IP lawyers? I'm not talking about Ram Kumar sir. He's the best. I mean, you can go to him and he will ensure that enforcement can happen. Enforcement is the most important thing for us. Time and again, Indian judiciary, like for example, I'll say this: there was an amendment brought to the Patent Act recently. All appeals against the patent authority are to the High Court now. The High Court is to constitute a special bench to deal with all IP matters. That has not happened till now. Am I correct, sir? And these cases are limping. Second point, all copyright IP matters courtesy are designated to the district court. No lower court judge will examine it if there is an infringement. Imagine somebody at a very remote corner wants to prosecute a matter on IP. We talk about all of these things. The lucrative idea of making money in terms of challenging an infringement. My view is that the system has to evolve more. There's a lot of training that is required on the judiciary side, because today we live in a world where the IP can be infringed left, right, and center. In a world of digitization, you can manufacture, manipulate, create anything you want to. So we have a problem in terms of enforcement is concerned. I tell you some of the matters which we started off in, like we filed cases against TCI. In fact, we were the first gag order which took out in 2018 against all the pubs, about 67 pubs, where they were playing Bollywood music labels, which my client had rights. Now, while trying to enforce that, we could get one gag order. After that, we were now. Now, what happened after about 2025? I'm talking 2018, 2025. 50% of the pubs have been shut down. Now, where do I eke out my remedy? If there is a delay in an original side, the recourse is also dead with it. This is the challenge of enforcement. Nevertheless, I think more training is required, dissemination of knowledge is required. The benches also have to be trained. Special constitutional bench. In fact, there is a discussion that has come up. Even like you have commercial court concept, you should have an exclusive tribunal IB tribunal. That is what we, as lawyers practicing on that side, feel we need that so that we get some instant, recourse. Thank you, sir.
Saurabh sir, in your litigation experience, are we seeing courts becoming more sensitive to the nuances of music and copyright infringements?
Very good morning to all of you. First of all, I would like to thank the organizer for giving me an opportunity to be a panelist here today. In the august presence of all my seniors in the field. Sir, the courts are obviously getting more and more sensitive and more aware of the scenario today. As later yesterday, Honorable Delhi High Court has slammed the fine of rupees 2 crores on A.R. Rahman, if you know, in a case against a folk singer. That is the scenario and that is the need of the hour. How do you say that a song is original? All the originals were composed in back the cinema was born. Now only the remakes and versions of the songs are being created. You cannot find originality in any of the songs present today. So the need of the art is protection by the court.
I just want to add this. When you talk of originality, I'm reminded of a case which I did almost about 8 years back. This was filed by PPL against us, and I took a very, very preposterous ground. I told the judge, I said, look, a DJ is like an artisan, right? A potter. What does the potter do? He'll put some mud on the wheel, then he will start molding. So initially, he doesn't know what he's actually doing. The pot comes as he starts molding. So I told the court, look, similarly, a DJ is an artisan. He takes one song from here, another song from there, third song from there, and he has to mix it in such a way that that continuity flows. That is his creativity. So if you can bring Kala Chashma and Kantalaga together and make it look like Kala Kantala, it is different. Right? So, mashups and all that. There, what happened? The judge understood me well. Very rare for a lower court judge to understand so well. He gave me an order saying, yes, the work by a DJ is the original work. I suppressed that order because I didn't want to get into problems. So that order is suppressed. But the judge said the original, if the DJ has put in some effort there, that amounts to original work.
Correct. Suresh sir, how does your firm advise clients when their music is used without permission on platforms like YouTube and Instagram?
Okay, that's a very tricky question. If it's YouTube and Instagram, now YouTube and Instagram are virtual platforms. Today, we have the IT Act that regulates it, and then we have Copyright Act on the other hand. Rights for enforcing copyrights are related to the Copyrights Act. But when you want to deal with the virtual platforms, you have to go to the IT Act. So what happens when a client comes to and says that, sir, some person has played my music and this is posted on the virtual platform. What are my recourses? My recourse is one, go individually against the person, file a case. Two, issue a notice to YouTube or any of the virtual platforms under the IT Act. Now there is some guidelines which have come about in intermediary guidelines which have come about in 2022. Those guidelines are in 24 hours, all these virtual platforms have to pull down the content. There's an obligation on them. This most public is not aware, sir. Very recent. In fact, we started invoking it. But unfortunately, these virtual platforms are not actually getting back to us. They're expecting us to go to court and get a judicial order. All the while, they said from the date of knowledge is what the court says. Court order is knowledge. This is what Google case is talking about. There was a case
Correct.
filed,
Court order.
Moksha Industries versus Google. In that they said court's order is actual knowledge. So when a court gives a knowledge, that only can be put down. So steps to be taken. We issue our notices first. So statutory compliance. Then go to the court to get an entry order. This is a remorse.
Sure, up, sir. Artists often sign up more than they understand. What should musician always watch out in publication or distribution agreements?
Well, that question goes outside the purview of intellectual property rights as well, because it also, I would also like to throw some light upon the basic ingredients of an agreement between a song owner and the company which buys it. First would be the ownership of the song or the composition. Second would be the royalty part of it, the revenue part of it. In one of the some media reports, I heard that when Mr. Raj Kapoor, the great showman, for a movie he wanted to hire Lata Mangeshkar, she put her step down, put her down, and she said that I will only sing the song for you if you give me royalty, and it was unheard of at that time. So even she was a pioneer for making that happen. And then there is the dispute resolution clause, whether there should be an arbitration or not. Then there is also the broadcasting rights, who should have them. And then there is a very notorious clause, which is the exclusivity clause. Very recently, a very well-known bhajan singer these days who sings Hanuman Chalisa on over YouTube. You know who I'm talking about. He told me that a media house signed him on exclusive contract, and he had to get intervention of a political figure to free himself from that foundation. So that's the scenario.
Ashok, sir. Can an artist challenge a remix, distort their message, even if it is signed away reproduction rights?
If I answer that, I'll give some lead to Mr. Suresh. I don't want to really answer that. But
Already told I'm a regular.
But according to me, now what exactly the distortion is supposed to be decided? Right?
Yes.
Are you taking it in the negative sense or are you taking it in the constructive sense? Like a moral right in a copyright. That is the only right that cannot be transferred by the owner of the copyright. Moral right always remains with the owner. What is the moral right? It is the right for, the artist can object any distortion or mutilation or modification of that particular, work that harms their honor or reputation. Having said that, can we say that remixes are distortions, right? Even if the original song is taken and a new tune is added to it, can it be a distortion? The fundamental test for distortion is, are you actually what is called as, mutilating or modifying the work in insult of the author? That is what is distortion.
Suresh, sir. With music now live on YouTube, Spotify, and Instagram, enforcement is messy. How do you advise clients whose music is being used without permission again? Now, if someone has it on Spotify, how it is reused? Any enforcement on?
That's a straight answer because if you say it's a question of infringement, Spotify or any of the online platforms, they have licenses.
Okay.
Without license and all, because let me talk a little bit about what in the bonding session Kumar sir was talking about. We're talking about PPL and Novix communication. I am the counsel for Novix communication. In fact, he would have been the counsel, he would have accepted it. But I became the counsel for Novix communication. The exercise of rights in both capacities. One is as an individual right, you're an owner of it. Original content is like producer's rights. Hero, Shimaru, Z Network, all these are big brands. They spend about 300 to 400 crores to make a film, which goes with cinematography rights, sound recordings. Now, this music is to be exploited by the owner in which forms. He can exercise it by way of an assignment, or he can do it in his individual capacity. Like assignment, we talk about the general power of attorney. I, as an owner, can delegate my right to somebody saying, you exercise my right in mutual capacity. And I'll also issue licenses. Now, if it's a different matter when I get to section 33, that why did they bring in the concept of there being a society? That's an argument. I won't get into that. What is relevant in the context of this is it not a case that everybody shall obtain a license? You know that that work is not yours, yet you use it. Do you not want to acknowledge it? You have to acknowledge it. You also have to pay certain royalty. This is what both me and Ramkumar sir always have a consensus. I says it doesn't matter. You are playing somebody's music. Like for example, if you talk about weddings and functions, all mehndi functions, you play music. There's a I think exemption under some Z 52Z, which says that religious events there is an exemption of use of music. Now self consumption is different. Public consumption is again different.
Correct.
When you try to commercialize, that is where the problem comes in. But your self consumption on YouTube is better. But when you commercialize, penalties will start opening. Now, in this context, let me explain this. When you say in religious events also, DJ music is not religious events. Devotional songs and music, religious events. Not DJ. You play some Gayatri mantra, it is devotional. But if you play Chala Chashma, it is not devotional. So that is not religious. So the moment you start using this, these owners will spring into action. So all these entities which are operating to provide free music, whatever it is, they will obtain license. Like Volga videos, Telugu music, because local is the focus.
Correct.
So these people, all of them shall obtain a license. This is what court has said, including the recent judgment. Court has said, one of the judges said, you expect the owner to watch his rights being infringed and do nothing, and you bring in a fiction called "Be a Society" and then license. Society, no doubt, is brought in the context of trying to regulate the price. It is monopoly versus individual rights. How do you want to balance it? So that is where this thing is coming. But in terms of license is concerned, the rule is shall obtain license.
Shall obtain.
You know it's not your work.
Correct.
None of these entities will do. They shall not do it.
Ashok sir, is takedown notice a viable strategy or should artists pursue court-backed injunctions even for online misuse?
Takedown notices, I very less experience of having had a takedown notice, issued a takedown notice and it was taken down. But as a lawyer, let me be very clear. Nothing works like an injunction.
Correct.
You have a perfect case, all the three principles, prima facie case, balance of convenience, irreparable loss, put them in their place, argue the case, get an injunction, fine. Now,
Correct.
I appeared for one restaurant called as Santosh Dhaba, the original guy. There I obtained about 58 orders. About 6 went to the Supreme Court. Supreme Court confirmed that yes, they are the original owners of the mark. You cannot infringe. Now, what is happening? Suppose, let us take, I go for a takedown. Takedown generally happens in copyright, more in copyrights than in. Now, let us take YouTube. YouTube has got a facility where you can actually strike.
Strike.
You can have a YouTube copyright strike.
Copyright strike.
But you don't have this facility in other platforms.
Hmm.
So even there also, what I disagree with that, because by doing a copyright strike, you are automatically agreeing YouTube is an arbitrator
Hmm.
or a judicial authority who can take a call on your work. That is not the way how it is done. YouTube should have a department that receives the complaint, and the complaint has to be addressed to the infringer. Then, when the infringer is not willing, the YouTube has to again tell the owner he is not infringing. You take your steps. But YouTube saying yes, you can do a copyright strike, and then yes, we are going to take a call on it is not right. So these are all lot of gray areas that needs to be looked into. But takedown notices, they are very well known in US because there, you send it to the intermediary and say, please take down this, immediately it is done. Here they need a court's order. Though the intermediary, rules say that it has to be taken out in, for 48, 24 hours. 24 hours. 24 hours it has to be taken out. Still they don't take it out.
Correct.
Right?
Sorry, sir.
Just like to add one.
Yes, sir.
Oh, the role of intermediaries has become a big challenge, as sir has rightly said. The latest guidelines of the 2022 notified by the government today mandates them to comply with the 24-hour notice. But you know what they're doing? They're going back to the very old rule, taking a shelter under 79. Under the IT Act. They're simply saying it's a judicial order lenient to pull down. And this is setting a different trend altogether.
What policy reforms do you believe could better protect artist rights while balancing public access and remix culture? What policies do you think can be made
For
for a better artist rights and remix culture to protect the remix culture?
the keyword here for intellectual property, any of the intellectual property is the originality. The main intention of the legislature as well as the enforcement should be to protect the originality. Steps are to be taken to protect that. That is the only keyword. Though my seniors are there, they can better comment on this issue.
Very good question. Is solved for the youngsters. Because in this, Honorable Justice Prakash Rogar asked, origin to what extent can you go back? Suppose I take Tyagaraja's Pancharatnavali. 60 years is a lifetime any copyright will enjoy. After that, they're in public domain.
Correct.
Ramadas Sankirtanas, Tyagaraja, whatever he's given to the world, all that music, to what extent originally you can go back to ask for it. Can someone claim a copyright on it? But adaptations like novelty, if you bring in a novelty, all of them base foundations of all composers, we base it on Tyagaraja Sankirtanas. And whatever Pancharatnavali or the basic Sarigama Padanisas are given. That is the basic notes on which you build. Ma.
Someone is recreating that song.
Recreation is what I'm coming. Or adaptation in your own way. All compositions are based. It's like nature's rhythm. Correct? Nature has its own rhythm. Like how you trap it into an instrument and get the music out. So it's the art and the skill. That skill becomes original. On the foundation of what was already laid down, if you bring in a novelty, that novelty will assume copyright. So the base foundation will continue. Hope I'm answering your question. That because all of you must know, because it's a very valid question in the context of music and copyright. You need to understand.
This is laid down that particular procedure that this particular rag has to be sung in that
form.
particular tune.
Not denying that raga. Suppose you take one of the Shankaracharya, one of Tyagaraja Sankirtana. Take one of them, whichever is good. Some Jagadananda Karaka songs. It has to be sung in a certain mode, is what we believe.
Yes.
See, it has religious sentiment associated with it because it's singing in the praise of Lord Rama. It has religious, attribution to it, and then it also has another way music, Sankirtana learning. Every day you learn Sarigama Padanisa and whatever you want, right? The basic notes. But when you are composing a music, you can inspire yourself to take those basic notes, and then you can come out with a different tune altogether, but not the same words of the song. You understood? If you look at most of the songs, including that song which was played in the morning, it has some Sangeetam somewhere, some note it is. You understand? They say that some of the notes you take, which are on a high tone, like Hindustani is different, Carnatic is different, correct? So both, if you take two compositions and compose something new, that becomes noble, right? You're not actually affecting the original note which is here. You're not affecting it. It may hurt. Somebody might say. Like Kamal Hassan made a comment saying, Tyagaraja lived the life of a beggar, seeking alms around and then singing the praise of Lord. He made a very controversial statement. That was not accepted by music lovers and Tyagaraja's fans. They went heavy on it. Similarly, your emotional attachment and traditional attribution to a particular song is different from it being adapted or inspired from it to create some novelty is different. That's very important. See the novelty part of it. This is what the Senior Counsel Ramkumar sir was saying. If you adapt it, if you take adaptations from it, you create something from the inspiration of it, but not the same, not the content, the verses of it. Then it is something new. I hope this is only just for the youngsters to understand because it was asking.
Apart from that, suppose I am adopting Tyagaraja, again the moral right will come.
Correct.
You cannot mutilate it or you cannot. So, first, the moral right is always like a dam, right? It could be in the public domain, it could be anything. Just because, see, there was this concept few years back when I was practicing in information technology saying, you put the article on internet, so you invited people to copy it. No, that is not the thing. Just because I put it on public domain, it is not a permission for others to copy. Similarly, when I'm taking Tyagaraja Kirtana and then the moral right stands as the first dam. I cannot breach it. If I modulate it to a different way, yes, as long as it is not in the moral right jurisdiction, it is acceptable.
I hope your question is answered.
But sir, recently what I have seen on a social media that one particular verse from Saundarya Lahari, he has sung it in one person has created in a jazz version.
Yeah.
You have Hanuman Chalisa being sung by Germans in jazz version.
Yes. Yes.
There's nothing wrong with it.
Okay. So
They,
that
they,
can
they have not mutilated the song, they have not mutilated the words.
they have they have not
Shiva Sahasra Yojana Parajat. That's a technically distance between the earth and the sun, which was written in those days. That is not changed, right? You can have in a different percussion, you can have in a different form of music, you can have it in, yes,
So it's a new presentation.
New present.
new presentation.
New presentation, same lyrics.
New lyrics, it's fine. The point is, emotion is bigger than the adaptations and
Yeah.
the changes. Because emotion attached with it is the way you serve it. Why do you talk about culture? Culture is a certain style. You can't mend it all with it. It has certain meaning for everything. Why is it a certain method and way of performance is meaningful?
Sir, everyone knows whatever is available on internet or social network is on by default copyright. So, how we know? But seeing that video in YouTube or somewhere, whether it is copyrighted or it is, that is one question, sir. And other thing is nowadays all channels, whatever the television channels are uploading the same videos in again in YouTube somewhere. But is that also protected because already it was aired in a TV channel. Again, they are keeping. Is that any protection is there?
The first point is whether can you copy something from the internet or not. You cannot do it because there is an inherent copyright in it. Now, how people declare it is a question. I did one case about 11 years back where one Indian Ayurvedic company had downloaded images from the internet and adopted it for all their medicines. In a matter of 3 months, that company got closed because they raised the claim of your millions of dollars that was taken from some South American country. So you need to check. One, two.
Where I need to check. That's right.
You need to see. Generally, there is a declaration, but if it is not a declaration, it does not permit you to copy.
But YouTube, if you say YouTube,
I come to YouTube. I come to YouTube. I am still talking of internet.
Right.
The second issue is open licenses are there. Right? When you go for a particular program and you take the open license, you can use the open license, add something to it, you get a copyright for what is added. That is if the license permits. If the license says you can't, I can't permit you to get it goes back to him. The third one is the YouTube. Most of the time, that is affected by something called as a broadcasting right. Right? Like you have a right for an author, you are similarly broadcasting. But what happens is when the clip is so very small, especially news which you are talking, there is no copyright on that because it is always in the public listing. So let us take a program is being shown, a particular clip. Generally, a 1 minute clip is permitted most of the time. 1 minute clip is permitted, no difficulty on that, on fair use, just to share, because it does not, the video does not show A to Z, it will only show some part of it. That can be permitted. But again, all these are subject to the rules and regulations, terms and conditions of YouTube, which you will have to go to.
How to find out whether
Disclaimers.
They go to disclaimers. Every site has got a disclaimer.
Google.
Copyright disclaimers, you have so many disclaimers.
internet I can find out their copyright, their mentioned.
I will put it this way. Your knowledge about copyright is more significant than the disclaimer. All of you please get to know about the rights because they're not your content. This session is actually disseminating that knowledge. Through this session, your understanding copyright is superior right. In fact, if you see from a criminal law realm, it is a non-compoundable offense if you commit an infringement.
Correct.
We see it that way. Because when you see a civil recourse, I see a criminal recourse. It is non-compoundable. And it's quite serious.
Especially in copyrights.
In copyrights,
Very serious.
very serious. Because please don't get it. Forget about disclaimers. You know it is not yours. And the word is broadcasting rights. Before YouTube came, how did ETV sell its content to viewers in US? Or how did any of these Indian channels send their content to somebody overseas?
Broadcasting.
It is broadcasting rights. And when you know it's broadcasting rights, see, the question comes again, exceptions are fair use and fair dealing. That's all is exception. You'll have to think from that perspective. Forget about looking at disclaimers. First, get this knowledge that it is not yours.
Correct.
It is somebody's. Get that basic understanding, basic tenets of corporate law. Then you get clarity. And how to use it, fair use it, you understand two things. Whose right is it? Copyright is somebody's right. What is fair use? Learn what is fair use. What happens if fair use has been violated? Infringement. Infringement leads to where? To the court. This is what 4 mantras you need to do. Nothing more.
Any other question?
In fact, I have one event at 3 o'clock, my own firm's event, where I have prepared a PPT. Verdict IP is my firm's name, not VRDICT, WORDs. Now, when I am giving the presentation, I bought a song from Hooper. It was a percussion of Carnatic as well as I bought the song, I spoke to them, I said, I want this song, I want to play it. How much? I paid about 2,000 rupees for the song. And I am given now a lifetime license to use that song only for that PPT. That is, I can put the PPT, play the PPT anywhere, and no one can question it. So it is always better. See, though I am defending a lot of people, but I fundamentally agree that you cannot be a pirate. You are taking away someone else's. That is why it's called an intellectual property right. Something that emerges from out of your head. It is your property and you have the rights on it.
People are circulating YouTube videos.
Unfortunately. See, let me tell you, internet is the biggest, gigantic copying machine. Right? What comes in the morning in South America is already there in Nebraska by the evening. What evening? Even 1 hour. Instagram.
Trending on.
That funny Thailand song is trending so much. It's all over the place. Some stupid song is there, and that feel goes away. Just memes. I guess that session is that memes and Marshall said.
Correct.
When making reels, so we get the new music on Instagram which people add the reels. So are those like
Yes.
Very little. 10 seconds. Reels
Yeah.
don't go for 1 hour, right?
yeah,
They go for 10, 15.
the 3 minutes?
There is a smile,
3 minutes.
there is a turnaround, and then the reel gets cut.
Yes.
Right?
Yeah.
So, that little bit of music you can, there's no doubt on it.
Okay.
That's called as fair use. It's not commission.
The commercial exploitation that lands into commercial exploitation.
Then it
Because
Then
the
it
next
becomes-
revenue, then the original owner will get spring into action. That you have to be careful always.
When your followers are increasing, you have to take like
You have to be careful because your followers, see, the owner is going to watch you.
yes.
See, Google expects you to watch. What's Google's business? Google wants you to be glued to it. That's it. You have to be glued to the screen. It makes money. One child asked, one of the top of the Google office, I said, well, how do you make money? He said, we make money. People just have to subscribe, comment to our web. That's it. We make money. Lot of money.
Many creators also asking them to forward, circulating, this is the subscribe. So everything they only encourage.
No, that's true. But your knowledge is very important. See, because the whole focus of this session of dissemination of knowledge is.
No,
Because
just
if you learn, then probably you will also be a responsible citizen.
Correct.
As a respected counsel, for a PPT, he took a license. Ideally, nobody does it. No one does it. With great respect, I'm saying this.
Yes.
And 2,000 rupees is lesser cost than the infringement cost.
The attitude which everyone has having.
Exactly. That's what has to be. That has to be inculcated, right? The whole purpose is that. 2,000 rupees is cheaper than actually infringement. What would they be sold?
Correct.
They'll be sold with heavy.
Again, it is not a commercial thing. It's not going. I'm not going to charge
He
anything.
could have not. He could have. It is a fair use because educative purpose is a fair use.
Just because I leave the door of my house open, it doesn't permit people to steal,
That's where the law comes into rescue.
right?
The session has brought crucial insights from legal blind spots in music contracts to complexities of modern content creation. My sincere thanks to Ashok sir, Suresh sir, and Saurav sir for their generous wisdom. Remember, your song deserves rights, not just likes. Thank you all for being an engaged audience. Let's continue and support to protective creative expression, legally and loudly.
We should understand that intellectual property is not just academic and it is essential.
Future is about protection of your ideas. How you protect your dreams?
How can we protect? Can we protect it at all?
Women's energy should not be at home, it should come out.
I gained a lot of knowledge today. Thank you.